Thank you, Your Honor. Counsel. Ladies and gentlemen of the jury, the evidence will show beyond a reasonable doubt that this defendant was found asleep and naked in bed in a house that a terrified naked woman escaped from after being repeatedly assaulted and raped by this defendant. Two decomposing bodies were found inside, having been kidnapped and murdered by this defendant. This defendant subsequently, over the course of multiple interviews with law enforcement, confessed to every element of every crime with which he is charged. This is not a whodunit case. This is a he did it case. The discovery of this defendant's crimes began Tuesday, September 13th, 2016. At 6:48 a.m., a woman called 911 from 363 Covert Court in the city of Ashland. 363 Covert Court is a yellow two-story house sitting just a couple of feet from an identical-looking structure. Both houses are across the street from the laundromat on 4th Street. These houses are supposed to be vacant. At the time, they were owned by Pump House Ministries, and other than the laundromat, neither house, with the exception of the other, is near anything. The area is desolate, lonely, and despite being out in the open, in a way secluded. Although 363 Covert Court was supposed to be a vacant house, it was very much occupied in August and early September of 2016. The defendant had chosen to take up residence, and although he had the run of its basement and 2 stories, he chose to consolidate his assets in a room just off the kitchen, separated from the rest of the house by a blanket affixed to the wall. He had scouted the house. He had watched it for a couple of days. He wanted to be sure no one would mind if he moved in. When he first came to town, he was living in the Hess and Clark building, an abandoned commercial factory just up the hill from 4th Street and Covert Court. You will hear the defendant make mention that frequently others would enter the Hess and Clark building. So the defendant found the privacy he sought in the unassuming yellow house across from the laundromat. Although the house had no running water, the electric still worked. He supplied himself from around town, even working at Save-A-Lot for a couple of weeks. But the defendant's privacy was spoiled on September 13th, 2016. As a woman called 911 because she'd been kidnapped and was in fear for her life if the defendant awoke. He had fallen asleep after having been awake for 2 days while he repeatedly assaulted her. She slipped off restraints that had her tied to the bed, found a cell phone, and called for help. Her voice was full of desperation and fear, and rightly so. She's engaged in a last-ditch effort to save herself from this defendant. Police officers arrived on scene and became confused by the identical nature of the houses. Running from house to house, trying to be quiet so as not to wake up the defendant, but growing more desperate as the minutes passed. After trying a metal screen door and finding it locked, Officer Dorsey moved around to the back of the neighboring structure, only to be called back by the dispatcher, relaying that the woman on the telephone had heard a bang at one of the doors. As the officer looked back to where he had just been, he saw a hand in the window. Seconds later, they were able to open the door and extract a bruised, terrified, naked Lori Spillick from 363 Covert Court. The officers made entry, passing through the kitchen, taking a right turn into the bedroom, and there on the bed was the defendant, naked and asleep. He was taken into custody, removed from the house. The officers immediately noticed the restraints tied to the bed. Officers began what they call a sweep, moving from room to room, finding no one. The door leading to the upstairs of the house was locked shut. They found the door to the basement was locked by a sliding lock with the knob broken off. After some prying, the door opened. When they went into the basement, they found a large pile of trash next to the stairs. And although they didn't see anyone, they will tell you the smell was unmistakable. Experienced officers know the smell well, and they will tell you it is unforgettable as it is unmistakable. After sweeping the house, the officers went outside. A call was made to the Bureau of Criminal Investigation, known as BCI, so that crime scene technicians could come and process the house for any evidence relating to Lori and her 911 call. But the smell of death told them there was going to be more to this story. They drafted a search warrant so that BCI could more thoroughly search that house. Now, the defendant came to the house on Covert Court by way of the Hess and Clark building. But that's not where he started in Ashland County. The defendant arrived in Ashland County in June of 2016. His first order of business was to burglarize 2 campers at Charles Mill Campground. Defendant took up residence at Lot 307, Charles Mill Lake Park. He did so by crawling through the window off a little porch area attached to the camper. The camper belonged to Tom Molinex and his wife, who has since passed away. In the summer of 2016, Tom Molinex had been down to their trailer at the campground, and he had put the awning down and the chairs out in the porch area and got the camper ready for the season, so that if his wife's health permitted, they could make a visit. The camper was completely set up for someone to reside in it. It's a standard camper with a living room area, kitchen, bedroom, small bathroom. Now, the defendant crawled through the window of Lot 306, the camper immediately next door, where he stole food, supplies, a DVD player, and a television set. She took back to Lot 307, where he was living. Lot 306 is the camper of Pam Miley. Ms. Miley spent her summers in and out of that camper, and it was also completely set up for someone to live in a similar fashion to Mr. Molinex's trailer next door. Pam Miley came to check on her trailer on June 23, 2016. Upon entering the camper, she found she had been the victim of a burglary. She called the Rangers, who came and took a report, snapped a couple of pictures, but had no real leads in the case. Not until 7 days later, on June 30th, Mr. and Mrs. Molinex came to stay in their camper, and upon opening the door, found the place trashed. Clothes strewn about. Cupboards open, nothing put away, the entire camper in a state of disarray. They too called the Rangers, who processed that camper for evidence. They found a couple of things of interest. The first some items of clothing that they collected and sent off to the laboratory at BCI. Scientific testing confirmed the defendant's DNA on those clothes from inside that camper. And what is perhaps a more telltale sign, they found a strange blunt object, clothing wrapped tightly and covered in a condom, looking very much like a homemade sex toy. They found this particular one in the Molinex trailer jammed in a tub of butter. You will see these devices in the photographs of 363 Covert Court. They are one of two signature items belonging to this defendant. This defendant will subsequently confess to the Ashland Police Department detectives that he didn't just break into these two trailers, he in fact broke into three, all right next to each other. He almost got caught when the old man, Tom Molinex, came to the one he was living in, but he wasn't there at that time. He was walking up the lane towards it and saw the Rangers arrive. Just a few minutes later, and they would have caught him. The defendant has been charged in counts 21 and 22 of the indictment with burglary, which reads, count 21. In that on or about the period between June 19th, 2016 and June 30th, 2016 in Ashland County, Ohio, Shawn M. Grate, by force, stealth, or deception, trespassed in an occupied structure, to wit, one trailer, located at Lot 306 at Charles Mill Lake Park, with purpose to commit in said occupied structure any criminal offense in violation of Ohio Revised Code, Section 2911.12A3, burglary. Count 22. In that on or about the period between June 19, 2016 and June 30, 2016, in Ashland County, Ohio, Shawn M. Grate, by force, stealth, or deception, trespassed in an occupied structure, to wit, one trailer located at 307 at Charles Mill Lake Park, with purpose to commit in said occupied structure any criminal offense in violation of Ohio Revised Code, Section 2911.12A3. And the state will submit that at the conclusion of the evidence, you will find that the defendant's DNA, signature sexual device, and his confession will prove him guilty of counts 22 and 23 as contained in the indictment. Now, after being deprived of his residence at Charles Mill Lake Park, the defendant moved on. He moved just down the road to a patch of woods outside the village of Mifflin in Ashland County, Ohio. Later, he will tell Detective Major that he had been making trips from the campground to his fort, as he calls it, in the woods. He was stalking the fort from those campers at Charles Mill Lake Park. So when the time came, he would have somewhere to go. You will find that this level of thinking, this level of planning, this level of premeditation is part of everything this defendant does. He stayed there in July of 2016. And again, supplied and sustained himself from the local area. On July 11th, 2016, an employee of the Mifflin Flea Market, located at 60 Main Street in Mifflin, came to open the store in the morning and found that overnight it had been broken into. The perpetrator had dropped through the roof onto the floor and stole various items, reported in part to be cash, a blue cooler, some tasers, and paperweight that looked like brass knuckles. Then propped up the garage door with a trash can and exited the building. Sheriff's office responded to take that report at that time, but didn't find a whole lot to go on. Not until September 13th of 2016, when the defendant tells detectives he was living in the woods by Mifflin. He describes in detail the location of his fort. He also describes breaking in to the Mifflin flea market. The defendant includes the details of the noise the cooler made as he drug it back in the dark from 60 Main Street in Mifflin, up the hill through the woods to his fort. The sheriff's office went to the woods after the defendant's confession and found his fort. It's a structure made of shower curtain, sleeping bag, some dead trees. Out in front of the entrance sat a blue cooler with pop and popsicles from the Mifflin flea market. Now, back at 363 Covert Court, crime scene technicians found 2 tasers in the bedroom of the house and the paperweight brass knuckles. The defendant further says those came from the break-in at the Mifflin market. Mr. Connor, the owner of the flea market, will identify them as similar to what was sold in his store. And the break-in at the Mifflin flea market is contained in count 23 of the indictment, and it reads as follows. Count 23. In that on or about the period between July 10th, 2016 and July 11th, 2016 in Ashland County, Ohio, Shawn M. Grate, by force, stealth, or deception, trespassed in an unoccupied structure, to wit, the Mifflin flea market, located at 60 Main Street, Mifflin, with purpose to commit therein any theft offense as defined in section 2913.01 of the Revised Code, or any felony in violation of Ohio Revised Code, section 2911.13a. Based on the recovery of the items in the defendant's possession, his admission to the crime, the state submits you will find at the conclusion of this trial the defendant guilty of count 23 as charged in the indictment. Elizabeth Griffith was a 29-year-old woman who lived at Stony Creek Apartments off East Main Street in Ashland, Ohio. Elizabeth had her share of problems. She was diagnosed as a schizophrenic. She received treatment at Appleseed Community Mental Health Center. And though she had significant mental health issues, she was functional day to day. She rode the bus to take care of her errands. She had lunch at the Kroc Center. She maintained her apartment on her own and was generally described by those that knew her as very nice and innocent. She was almost childlike in her manner and her mentality. After August 16, 2016, nobody ever saw her again. She missed a couple of her scheduled appointments at Appleseed, which her counselor found unusual. Counselor found it even more unusual that Elizabeth hadn't called the hotline in a couple of weeks. The hotline's a 24-hour line that Appleseed maintains so that those in need can call when they feel they need to speak to somebody about what's troubling them. And by all accounts, Elizabeth was a frequent flyer on that hotline. Her counselor, Tina Schwartz, found this extremely odd. So she called police reporting Elizabeth missing on September 7th, 2016. Now, Ms. Schwartz did her own little bit of digging. She began calling around town to all the places that Elizabeth usually goes. And everyone she talked to said they hadn't seen her. She even went to Elizabeth's apartment, but Elizabeth wasn't there. She related this to police officer Cody Hying, who also made a few phone calls. He was told the same thing. Nobody's seen Elizabeth. The case was taken up by Captain Dave Lay. Captain Lay learned that Ashland Transit, on the morning of August 16th, had taken Elizabeth from the Aldi store out by the Walmart to Dorlo Pizza on Union. And from there, No one had seen it. The police executed a search warrant at her apartment. They found the receipt from Aldi's from the same day, August 16th, as Ashland Transit picked her up, leading to the conclusion that she must have come home from Dorlo. They also found some notebooks with some notes, phone numbers, things they hoped would be useful in tracking down Elizabeth's whereabouts and solving her disappearance. They found a calendar with a notation that on the 16th of August, see Cindy S., hopefully. Well, police tracked down a Cindy Swanger who had met Elizabeth doing peer-to-peer counseling and talked to her quite often. Cindy, however, maintains a barrier with folks that she does peer-to-peer counseling. She didn't want them just popping by her house. But Elizabeth knew she lived near Dorlo, and that morning after getting dropped off at Dorlo, called Cindy Swanger, wanting to come over. Cindy had a previous engagement. She had to go, so she couldn't meet with Elizabeth. Cindy will tell you that Elizabeth had been excited in the days leading up to her disappearance, that she had told her she met somebody she wanted Cindy to meet. Cindy never learned who it was. Cindy also hadn't heard from Elizabeth since Elizabeth called her in the afternoon of August 16th, and also found her disappearance to be strange. Now, by late morning on September 13th, 2016, the BCI crime scene technicians had completed their initial walkthrough the house at 363 Covert Court. They were beginning to scan and photograph the house as it was found before they collected items of evidence. As they proceeded to the upstairs unit, because the house is set up in such a way that one could live upstairs or downstairs, they entered a bedroom upstairs. There's a sofa with a fold-out bed, and the bed was folded out. The sheets are off the bed. They're crumpled up at the floor, at the foot of the bed. Tied to the frame of the bed, underneath the thin pull-out mattress, are more restraints. There are also restraints tied to the bed on the first floor, and there's a restraint tied to a chair in the bedroom downstairs that's positioned in the closet. Propped at the end of the wall is one of those signature sexual devices. It's a pole with a sock wrapped around one end and covered in a layer of condoms. It's against the wall near the foot of the bed. And there's a rocking chair to one side. And as the BCI technicians took in this room and its furnishings, they notice a pile of stuffed animals and clothing on the floor that extends not just across the floor, but up the wall, nearly to the ceiling. And it's in one corner of the room. And as they examined that pile of clothing and stuffed animals, there's fly larvae all over it. Telltale signs of a heavy fly infestation in this part of the house. They began to excavate that pile of clothing, removing the stuffed animals, removing the clothing, and they exposed a door. There's black tape around that door, between the door and the frame, effectively sealing that closet shut. Removing the tape reveals more larvae stuck to the tape, stuck to the door, stuck to the door frame. Inside is a small closet with another large pile of clothing on the floor, and yet more evidence of a fly infestation in the closet. The cans of air freshener that are on the floor of that bedroom make a lot of sense. As they began to excavate the second pile of clothing in the closet, they discovered the mummified remains of what dental records would positively identify as Elizabeth Griffith. She was naked. Her hands were bound together behind her back. And there's a restraint, a ligature, tied to each ankle. The restraint from her right ankle extends from that right ankle in a straight line and wraps around her neck. There's a similar restraint on her left ankle that apparently had come loose from whatever it was tied to. She was placed in the closet head first and face down. And her legs are bound in such a way that they're bent back behind her thighs with her legs spread apart, completely exposing her most private parts. Eventually, they had to cut the wall to get her out of that closet. She was in an advanced state of decomposition, thwarting the hope of recovering any forensic evidence from her body. The Cuyahoga County Coroner's Office determined she had been the victim of cervical compression, a form of strangulation. Now, on September 13th, the second officer to speak to the defendant was Captain Lay. The captain had been looking for a woman named Lori Spillig. He had been given her name as someone to speak to, as someone who was an acquaintance of Elizabeth Griffith. He had been given Lori's name by Tamara Whalen. He had interviewed Tamara, and finding Lori in the house that morning with the defendant made Dave Lay fear for Elizabeth. That morning, Captain Lay briefly spoke with Lori, getting just the basics of her ordeal, and then he initiated an interview of the defendant. While the conversation centered on Lori at first, Captain Lay felt this defendant would know something about Elizabeth. At the time that Captain spoke to the defendant, the crime scene technicians had yet to discover Elizabeth Griffith, naked, bound, and taped in the closet. So the captain asks the defendant, "Do you know Elizabeth?" And he says, yeah, he does. He describes her as crazy. In fact, he's rather derogatory about it. The captain says, "I think you know where she is." The defendant denies it. Denies it a couple times. Until finally the captain says, "Where is Elizabeth?" And the defendant tells him, "You know where she is." He tells Captain Lay that Elizabeth is in a better place. But he stops short of telling where or how she got there. The captain doesn't get the full story from the defendant. What the defendant doesn't know is that officers have yet to find her. So as you listen to that interview, as you listen to that evidence, it is important to keep in mind that the defendant is not fully cooperative with this process. Defendant will tell what he wants to tell, but as you listen, what you'll find is he stops well short of telling the whole story. Even as he gives multiple versions of his killing Elizabeth to Detective Major, and he admits to killing Elizabeth Griffith. What exactly happened to Elizabeth Griffith, we'll never know. And the defendant changes his versions of what happened, sometimes in an instant. He eventually gets around to admitting he knows where Elizabeth is later in the day, when he's talking to Detective Kim Major. He says he and Elizabeth played Yahtzee at her place earlier in the day, August 16th. He mentioned he was having some chicken at his place for dinner, and she came over to Covert Court for a sandwich and then left. But later that evening called him, maybe 10 p.m. or so, and asked if he wanted to play a game. Elizabeth's counselor, Tina Schwartz, will tell you that Elizabeth had trouble sleeping. The defendant says he met her at the YMCA and walked her the rest of the way to Covert Court that night. They came inside and played some sort of game with dice. Ms. Schwartz will also tell you that Yahtzee and a game called Farkle were Elizabeth's favorites. Farkle is a game played with dice. According to the defendant, she wanted to see the upstairs of 363 Covert Court. In one version, they go upstairs and the defendant puts his hands around her neck and began to choke her, asking her if this is what she wanted. Apparently, the defendant had decided that since Elizabeth had told him that she had suicidal thoughts from time to time, that he would take it upon himself to see if at that particular moment she wanted to die. It turns out she didn't. The defendant, as you will hear, describes her reaction. The defendant's hands on her neck caused her to scream. So the defendant decides he must choke her. And he puts his arm around her neck and slowly deprives her of the oxygen needed for life. In a subsequent interview, the defendant clarifies that he was thinking about killing Elizabeth even as they were downstairs. He describes to Detective Major that he could feel his heart racing as he thinks about killing her as they climb the stairs. When he begins to strangle her, she cries out, "Jesus, forgive him." And he stops. They talk briefly about salvation, and then the defendant finishes her off. When asked why she doesn't have any clothes on, the defendant at first says, well, she took her shirt off. She took her shirt off and was coming on to him. Detective Major asks the natural follow-up question, did you have sex with her? He then adamantly denies any sexual activity or ideation with Elizabeth. He immediately changes his story, that her shirt and bra came off in a struggle. But he doesn't describe a struggle or any sort of violent altercation that would cause the shirt and bra to come off. Then claims he took her pants off because she defecated when she died and he didn't want it to smell. But later describes trying to pry her mouth open to let the flies in so that they would hurry decomposition and lessen the smell of her body upstairs. He claims he did this with the sexual device that's propped up in the corner of that bedroom, just outside that taped closet door. And the real interesting part of that is that he's asked about multiple such devices that are found around the house. He claims that those are stress relievers, that he puts those in his own anus to relieve stress, and that he's never used any such device on any woman. Curiously, though, when Detective Major confronts him and suggests the possibility of finding DNA on those devices, this defendant says, oh, well, you might find Elizabeth on that one upstairs. And then tells the story of trying to open her mouth with that device so that the flies could get in. But what you'll see of the pictures, she's head first in that closet and under a huge pile of clothing. And the evidence will also show, as your own common information would, that flies don't show up. Not enough that you'd engage in such an act. So there's no way to accomplish the task the defendant describes based on where she is in the closet. Now, it turns out her DNA was not found on that device. But the experts will tell you that doesn't mean it didn't touch her in some way. And the salient point here is the defendant was worried about her DNA being found on it. The medical examiner at the coroner's office will tell you he can't say with any certainty whether those bindings on her leg, ankles, and neck were there before or after she died. The defendant, however, took the key to her apartment, and he took her cell phone, and after murdering Elizabeth, he went over to her apartment and let himself in. He had written the name Shawn on the top of his Yahtzee scorecard. And he took it and he tore it up so that no one would find it. From inside her apartment, he took some paper towels, some shampoo, razors, took some pills that she had in a drawer, leaving empty containers behind. He then exited the apartment, got rid of her cell phone. He says he broke it in 3 pieces, removing the battery, snapping the top off, flip phone, and throwing them into the creek behind the apartments. And despite looking, police were never able to recover any parts. He took the key and threw it in the bushes as he walked past the alley. Later, he tells Detective Major that he had done Elizabeth a favor by extinguishing her life. Elizabeth's key was located by the police department right where he said it would be. And in the house on Covert Court, bottles of shampoo, just like the ones in her apartment, are there in the bathroom. And the razors that he took are there on the tables in the bedroom. And those were found by the police. With reference to Elizabeth Griffith, the defendant is charged as follows. Count 1. In that on or about the period between August 16, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate purposely and with prior calculation and design caused the death of another, to wit, Elizabeth Griffith, in violation of Ohio Revised Code, Section 2903.01a. Specification 1 to that count. The grand jurors further find and specify that the offense as stated in count 1 was committed by the Shawn M. Grate as part of a course of conduct involving the purposeful killing or attempt to kill one or more persons or 2 or more persons by the said Shawn M. Grate. Second specification to that count. The grand jurors further find and specify that the offense as stated in count 1 was committed while the said Shawn M. Grate was committing, attempting to commit, or fleeing immediately after committing, or attempting to commit kidnapping. And the said Shawn M. Grate was the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 2. In that on or about the period between August 16, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate purposely caused the death of another, to wit, Elizabeth A. Griffith, while committing or attempting to commit or while fleeing immediately after committing or attempting to commit kidnapping in violation of Ohio Revised Code 2903.01b. The first specification to that count. The grand jurors further find and specify that the offense as stated in count 2 was committed by the said Shawn M. Grate as part of a course of conduct involving the purposeful killing or attempt to kill 2 or more persons by the said Shawn M. Grate. Second specification of that count. The grand jurors further find and specify that the offense as stated in count 2 was committed while the said Shawn M. Grate was committing, attempting to commit, or fleeing immediately after committing or attempting to commit kidnapping. And the said Shawn M. Grate was the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 3, in that on or about the period between August 16, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate, by force, threat, or deception, removed another, to wit, Elizabeth A. Griffith, from the place where the other person was found, or restrained the liberty of said Elizabeth A. Griffith for the purpose to terrorize or to inflict serious physical harm to the said Elizabeth A. Griffith. And further, said Shawn M. Grate did not release said Elizabeth A. Griffith in a safe place unharmed, in violation of Ohio Revised Code Section 2905.01A3. Count 4, in that on or about the period between August 16, 2016 and September 13, 2016, in Ashland County, Ohio, Shawn M. Grate, except as authorized by law, treated a human corpse, to wit, the corpse of Elizabeth A. Griffith, in a way that would outrage reasonable community sensibilities, in violation of Ohio Revised Code Section 2927.01b, gross abuse of a corpse. Count 5, burglary, in that on or about the period between August 16, 2016 and September 13, 2016, in Ashland County, Ohio, Shawn M. Grate, by force, stealth, or deception, trespassed in an occupied structure, to wit, Elizabeth A. Griffith's residence, located at 242 Matthews Avenue, Apartment L, Ashland, Ohio, with purpose to commit in said occupied structure any criminal offense, in violation of Ohio Revised Code Section 2911.12A3, burglary. Count 6, tampering with evidence, in that on or about the period between August 16, 2016 and September 13, 2016, in Ashland County, Ohio, Shawn M. Grate, knowing that an official proceeding or investigation was in progress, or was about to be, or likely to be instituted, did alter, destroy, conceal, or remove any record, document, or thing, to wit, one key, one cell phone, and or one Yahtzee game sheet, with purpose to impair its value or availability as evidence in such official proceeding or investigation, in violation of Ohio Revised Code Section 2921.12A1, tampering with evidence. At the conclusion of the presentation of evidence in this case, the state is confident you will find the defendant guilty of each of those counts and specifications as contained in the indictment. Stacy Stanley, aka Stacy Hicks, was a woman who came back into town for the day on September 8, 2016. She wanted a guy named Sonny to do her nails at Nails 2, a nail salon out by Walmart in the city of Ashland. Stacy used to live in Ashland, has family, they're here still. She had since moved to Greenwich. She stopped in at Nails 2 in the afternoon to see if Sonny could do her nails. He was busy with another customer and asked that she come back when he was done. So she went across the parking lot to Walmart. She's on video there, purchasing items to do her lawn. Several bags of topsoil, a load of brick pavers. You'll see her drive her sporty two-door Mitsubishi up to the garden department, where one of the associates helps her load all of that into that little car. You'll see all the pavers going into the trunk area and bags of topsoil go into the passenger compartment just before 7 p.m. She then returns to Nails 2, where Sonny painted her nails a dark purple, taking about an hour to do so. Now, unfortunately, you'll see those nails in pictures taken at the coroner's office. Somewhere along the way, Stacy got a flat tire and pulled into the BP station at Main and Union, right in the middle of downtown Ashland. She pulls her car over next to the air hose, which is over along the fence at the far side of the gas pumps. She then calls her son Corey, who's in Sandusky. They were going to meet up for dinner, but the evening got late. She wasn't quite done with her errands, and it was later than she expected. So by text message, late that afternoon, they canceled the dinner plans. But she calls Corey when she gets the flat tire. And Corey begins calling around trying to find somebody that can come help her change that tire. Now she's got a spare tire, but she doesn't have any tools or a jack or a tire iron in order to get the tire off. Eventually, a family friend by the name of Wayne Bright was contacted and agreed to come help her. It was raining that night, and as chance would have it, this defendant was walking past the BP. He'll later say that he noticed her standing there and that he was on his way to Circle K, just a couple blocks up Main Street. And that he went to Circle K and walked back along the same route. And when he came back past the BP, she was still standing there. So he went over and struck up a conversation. And she told him she had a flat tire, and he offered to help change it. But that wasn't going to happen with no tools. And she told him that the guy was coming, and that Wayne Bright rolled up, and when Wayne Bright got there, the defendant was still standing there. She introduced the defendant to Mr. Bright. And based on the Stacy and the defendant's demeanor, Wayne thought this was somebody she knew. He supplied the tools, and the defendant did most of the work, changing the tire out. And that must have been a job to get the tire out of there with all those pavers in the back. In fact, Wayne Bright will tell you that he assumed the defendant and Stacy had not arrived at the BP together, nor did he think they were leaving together, because the car was full of bags of soil. It didn't look to Wayne like anybody could ride in it. But after the tire was changed, Wayne got in his car and he left. And Stacy and the defendant went into the BP to get a cup of coffee. Stacy called her son Corey, telling him the tire had been changed. She had spoken to Corey earlier when he called to say Wayne Bright was on the way, and she told him, "There's a guy here offering to help." And Corey told her that someone was coming to help her with the tire because he was concerned that she was standing there with a stranger. A guy named Nathaniel Keck was working at the register at BP that night. When he came in to start his night shift, he saw the defendant and Stacy standing there by a car at the pump. And he remembers they came inside and she was on the phone talking to someone that he took to be her son. Stacy bought the defendant a cup of coffee and they walked outside. Then they disappeared into the night. Stacy disappeared somewhere between 10:30 and 11 p.m., September 8th, 2016. Son Corey works the night shift. From the 9th into the 10th, he realized he hadn't spoken to his mother that day, which was unusual. On his breaks, he made calls, tried to text. All of them went unanswered. On the 10th of September, the Huron County Sheriff's Office was contacted to report her missing. That would be the agency with jurisdiction over where she lives. On September 11th, Corey and other family members arrived in Ashland to begin the search. They fanned out along the streets of Ashland and at some point in the day, Stacy's Mitsubishi was located. It was parked on 9th Street, up the hill, approximately 3 blocks from Covert Court. The family was concerned when they looked inside. There were cigarette butts in the ashtray that were not her brand. The driver's seat was pushed way back. And although they didn't know it, the topsoil and the pavers were gone. They pointed out this to the Ashland Police Department, who noted it. An attempt was made to try to get video from the BP station, but the video surveillance system was broken. A witness who lives in the vicinity of that parked Mitsubishi on 9th Street came forward. The evening of the 10th, Saturday night, the witness was waiting on her boyfriend to arrive, heard a car pull up out front on the street, looked out the window and saw Stacy's Mitsubishi being parked with a white male exiting the driver's seat alone. She didn't see where he went. Now on the 11th, family members staked out the car for the day, but nobody returned to it. And eventually the police department had it towed. The keys to Stacy's Mitsubishi, along with the rest of Stacy's keys and personal items, were found at 363 Covert Court. But those Mitsubishi keys are in a jar next to the bed in the downstairs bedroom. Here we come to the defendant's second signature item in this case. In the trunk of the car was a bag of boxes of items known as love roses. Now, love roses are these little glass tubes with a little figurine rose inside. And there's a bunch of them in red boxes. And not just were these boxes found in the trunk of the Mitsubishi, but in the bedroom where the defendant resided at 363 Covert Court, police found multiple boxes of these love roses. And the connection between this defendant and those roses is unmistakable. It would seem that after Stacy bought the defendant a cup of coffee at BP, she gave him a ride back to his place on Covert Court. And once inside that house, she never left. Recall that officers in their initial sweep of the residence, after forcing their way into the basement, sensed something was terribly wrong downstairs from the smell. The stench of death was strong. And after Stacy was strangled, she was wrapped in a basement and taken down the basement steps. You will hear this defendant describe her head hitting the steps on the way down. He placed her on the floor face down, and then this defendant threw bags of trash on top of her, one after another, until she was obscured from sight. So much trash that even the officers that went down there to make sure no one was in the basement ever noticed her. Couldn't see her under all that trash. Her purse had been gone through, its contents dumped on the floor next to her and spread around. Her Huntington Bank debit card was eventually located in the defendant's wallet. Her Ohio Directions card was under the bed in the bedroom where the defendant spent most of his time. That same bed with the restraints tied to it. The defendant obviously moved the car using the keys he took from her so that it wasn't in front of his house any longer. He obviously drove it somewhere between the 8th and the 10th because Joanna Smith, the witness on 9th, saw him parking and exiting that vehicle the night before it was found. Moving the car away from Covert Court isn't a disorganized, irrational act. It's organized. It's the product of rational thought. The defendant says he made a couple of trips in it, There's no real reason to doubt that. For reasons we will never know or understand, Stacy Hicks entered the house on covert court. And what happened next is really insight into this defendant. He forcibly raped her. We know this because the defendant admits it. The defendant held Stacy at 363 Covert Court against her will, and he forcibly raped her by repeatedly forcing his penis into her mouth. He tells Detective Major that it was going well until she maced him. He gives two different versions of how he was maced, so we have to wonder exactly what happened. In one version, she was bent over the bed and maced him by aiming it away and up at him. In the other, she maced him face to face. Regardless, this defendant says he strangled her after he was maced. Police found her can of mace. It was on the basement floor under the trash next to her body. That isn't all, ladies and gentlemen. You will also see this defendant rape Stacy Hicks. He videotaped it with a cellular telephone. There are two videos of Stacy Hicks located by police on that phone being forcibly, orally raped by this defendant. The first starts with her begging to be let go. And he responds, "I said not until you get me off." And her reply, "But you already had sex with me." And he says, "But I didn't get off." And then he proceeds to orally rape her. You can see her exposed legs in the video. And in the surveillance video earlier that day at Walmart, you'll see that she had black leggings on underneath her skirt. He'll later tell Detective Major that about 15 minutes after he made that video, he killed her, strangled her. Same method he used on Elizabeth. A slow, personal way to kill. He then wrapped her in the blanket and threw her away in the basement with the rest of the trash. When she's recovered, she still has her shirt on. Her skirt is hiked up around her waist. Leggings are gone, no underwear. She is exposed from the waist down, except for her boots. He'll tell Detective Kim Major that he knew what kind of woman she was. You'll hear him describe her and use the words dirty slut whore. He tells Detective Major that at the time he filmed her, she was acting up. That she was fine until he began filming, and then she began acting innocent, like she was someone other than who the defendant assumed she was. You will see what it means to act up. The video will disclose, and the evidence will reveal that Stacy Hicks was begging to be let go. Acting up to this defendant means not doing exactly what he wants. The defendant decided, as he was conversing with her at the BP, that she was a flirt and a loose woman. He arrived at that conclusion because she told Wayne Bright, the family friend that came to help her with the tire, that she would call him sometime. That's it. The evidence will demonstrate that she went to get her nails done, tried to get her car fixed so she could get home out of the rain and landscape her yard. She was nice enough to repay what she thought was the kindness of a stranger by buying him a cup of coffee and giving him a ride home. And what she got in return was she was kidnapped, forcibly raped, robbed, strangled, and thrown out with the trash in the basement. The defendant has been charged as follows. Count 7. In that on or about the period between September 8, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate purposely and with prior calculation and design caused the death of another, to wit Stacy J. Hicks, a.k.a. Stacy J. Stanley, in violation of Ohio Revised Code Section 2903.01a. Specification 1. The grand jurors further find and specify the offense as stated in Count 7 was committed as part of a course of conduct involving the purposeful killing or attempt to kill 2 or more persons by the said Shawn M. Grate. Specification 2. The grand jurors further find and specify the offense as stated in Count 7 was committed while the said Shawn M. Grate was committing, attempting to commit, or fleeing immediately after committing or attempting to commit kidnapping and or rape and or aggravated robbery, and the said Shawn M. Grate was the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 8. In that on or about the period between September 8, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate purposely caused the death of another, to wit Stacy J. Hicks, a.k.a. Stacy J. Stanley, while committing or attempting to commit or while fleeing immediately after committing or attempting to commit kidnapping and or rape and or aggravated robbery in violation of Ohio Revised Code Section 2903.01b, aggravated murder. Specification 1 to Count 8. The grand jurors further find and specify the offense as stated in Count 8 was committed as part of a course of conduct involving the purposeful killing or attempt to kill 2 or more persons by the said Shawn M. Grate. Specification 2 to Count 8. Grand jurors further find and specify that the offense as stated in Count 8 was committed while the said Shawn M. Grate was committing, attempting to commit, or fleeing immediately after committing or attempting to commit kidnapping and or rape and or aggravated robbery. And the said Shawn M. Grate was the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 9. In that on or about the period between September 8, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate by force, threat, or deception removed another, to wit Stacy J. Hicks, a.k.a. Stacy J. Stanley, from the place where the other person was found, or restrained the liberty of the said Stacy J. Hicks, a.k.a. Stacy J. Stanley, for the purpose to engage in sexual activity as defined in Section 2907.01 of the Revised Code, with the said Stacy J. Hicks, a.k.a. Stacy J. Stanley, against her will. And further, the said Shawn M. Grate did not release the said Stacy J. Hicks, a.k.a. Stacy J. Stanley, in a safe place unharmed, in violation of Ohio Revised Code Section 2905.01A4, kidnapping. Specification 1 to Count 9. The grand jurors further find and specify that said Shawn M. Grate committed the offense in Count 9 with a sexual motivation. Specification 2 to Count 9. The grand jurors further find and specify that the said Shawn M. Grate is a sexually violent predator. Count 10. In that on or about the period between September 8, 2016 and September 13, 2016 in Ashland County, Ohio, Shawn M. Grate by force, threat, or deception removed another, to wit Stacy J. Hicks, a.k.a. Stacy J. Stanley, from the place where the other person was found, or restrained the liberty of the said Stacy J. Hicks, a.k.a. Stacy J. Stanley, for the purpose to terrorize or to inflict serious physical harm on the said Stacy J. Hicks, a.k.a. Stacy J. Stanley, and further, that the said Shawn M. Grate did not release Stacy J. Hicks, a.k.a. Stacy J. Stanley, in a safe place unharmed, in violation of Ohio Revised Code Section 2905.01A3. Specification 1 to Count 10. The grand jurors further find and specify that the said Shawn M. Grate committed the offense in count 10 with a sexual motivation. Specification 2, the grand jurors further find and specify the said Shawn M. Grate is a sexually violent predator. Count 11, in that on or about the period between September 8th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate engaged in sexual conduct, to wit, fellatio, with Stacy J. Hicks, aka Stacy J. Stanley, when the said Shawn M. Grate purposely compelled the said Stacy J. Hicks, aka Stacy J. Stanley, to submit by force or threat of force in violation of Ohio Revised Code section 2907.02A2, rape. Specification to count 11, the grand jurors further find and specify that the said Shawn M. Grate is a sexually violent predator. Count 12, in that on or about the period between September 8th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate, in attempting or committing a theft offense as defined in section 2913.01 of the Revised Code, or fleeing immediately after the attempt or offense, did inflict or attempt to inflict serious physical harm on another, to wit, Stacy J. Hicks, aka Stacy J. Stanley, in violation of Ohio Revised Code section 2911.01A3, aggravated robbery. Count 13, in that on or about the period between September 8th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate, except as authorized by law, treated a human corpse, to wit, the corpse of Stacy J. Hicks, aka Stacy J. Stanley, in a way that would outrage reasonable community sensibilities, in violation of Ohio Revised Code section 2927.01B, gross abuse of a corpse. Count 14, in that on or about the period between September 8th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate knowingly used or operated a motor vehicle, to wit, one 2003 Mitsubishi Eclipse, with Ohio license number GHK 7331, without the consent of the owner, to wit, Stacy J. Hicks, aka Stacy J. Stanley, and kept possession of said motor vehicle for more than 48 hours, in violation of Ohio Revised Code section 2913.03B, unauthorized use of a vehicle. Ladies and gentlemen, at the conclusion of the presentation of the state's evidence, you will conclude the defendant is guilty of those counts beyond a reasonable doubt. Now, when the defendant came to the city of Ashland in the neighborhood of July 23rd, 2016, he went to the Kroc Center. He went there looking for some assistance with housing and a telephone. He tried to see a counselor, but he was told that she was getting ready to leave for the day. He should come back Monday. So he came back on July 25th. He met with Sarah Fairchild at the Kroc Center, talked to her for a bit about being new to town, applying for jobs, and trying to get some assistance with housing and a telephone. He signed and dated the form for services that the Kroc Center uses. And Sarah didn't speak to him again, but saw him periodically around the Kroc Center for the next month. On July 27th, at 11:26 a.m., the defendant was entering the Kroc Center for lunch at the same time as Lori Spillick. He struck up a conversation with her and had lunch. Off and on for the nearly month and a half that would follow, they would have lunch at the Kroc Center from time to time and go for walks. Curiously, you'll hear this defendant claim they had lunch every day. Lori and the Kroc Center records will disclose it's just a couple times a week. Lori also lived at the Stony Creek Apartments. She knew Elizabeth Griffith. In fact, Lori was there when the defendant first met Elizabeth. And she told Elizabeth not to tell her whole life story to someone she just met. Lori is a deeply religious woman, lives alone, and enjoys physical exercise like long walks and playing tennis. The defendant would occasionally stop by. They would have lunch up at the Kroc Center. Then they'd go for a walk or up to Brookside Park to play tennis. Lori will tell you that she was never interested in any kind of extended relationship with this defendant. The defendant would make conversation. Through those conversations, he learned that she felt relations between a man and a woman should be reserved for marriage. She goes so far as to not to want his phone number because she didn't feel it was right for an unmarried woman to have a man's phone number in her phone. In fact, she wouldn't allow him to enter her apartment. He had been to her apartment, but when he was there, he would sit or stand in the hallway and not be permitted entry. This bothered the defendant. One of their walks even went to the fort in the woods near Mifflin. Lori will tell you that she didn't expect that long of a walk that day. But he had told her that he had a fort out in the woods and that he stayed there for a little while and would she like to walk to see it. And they began walking and walking and walking and did eventually arrive at this fort. There the defendant dug up a box of costume jewelry, bits of purple geode, and some other knickknacks. And he gave it to Lori. Now, she'll tell you that she didn't have any designs on this defendant and didn't regard him for anything beyond being someone to take a walk with or converse with at lunch. And to cement that, she took this box, this memento that they walked all the way to the woods in Mifflin for, that the defendant had dug into the ground for safekeeping, that when he gave her that, she slid it under her couch with her old shoes and junk. It's later recovered there by police. Hardly the actions of someone cherishing a gift from someone they really care about. The first officer to interview the defendant was Officer Kurt Dorsey. The defendant tries to tell Dorsey that the naked woman that they extracted from the house is his fiancée and that they were thinking about getting married. This stands in stark contrast to the actions of a woman who puts mementos from such a man under her couch. The issue of marriage, however, is linked, as you will find from the evidence, to what the defendant calls her lustful desires. It's Lori's belief that sex is reserved for marriage. And on September 11th, Lori and the defendant are walking down Main Street out by Walmart when Tamara Whalen finished her shift at 3 o'clock. She stopped as she saw them walking and gave them both a ride. She asked Lori if she had seen Elizabeth Griffith, because the word around town was that Elizabeth was missing. Lori hadn't seen her and didn't know where she was. Tamara will tell you that Shawn Grate sat there silently listening to the conversation. Tamara told Lori that she had spoken to a detective with the police department and had passed Lori's name along as someone the police should talk to regarding Elizabeth's disappearance. Tamara will tell you that she did this right in front of Shawn Grate on September 11th, 2016. When they pulled into the apartment complex, Tamara had been discussing wanting help to build a shed. And the defendant offered to give her that assistance, provided her with his phone number, and she called that number as they were seated there so that her number would be in his phone and they could contact each other about this project. But he said he didn't have the phone on him. But as he got out of the car, a phone fell out of his pocket. Tamara thought that was odd. He said he didn't have a phone on him, yet there one fell out of his pocket. And she didn't hear it ring when she called him. She also thought it suspicious that he walked quickly away from the car in a direction other than Lori's apartment, which is where she thought they were headed. She finished with her conversation with Lori and drove off. Lori and the defendant went up to her apartment. Lori made sandwiches, being late in the afternoon, and they talked. And again, the defendant had to sit in the hallway. They had been discussing some Bible verses and she offered to read them to him. And he was open to that. He told her there was a bag of clothes back at his house that his mom had given him to give to Lori, even though he hasn't seen his mom in quite a while. In fact, the defendant, as the evidence will show, wanted her to come over on that specific day. And she consented. And they walked over to 363 Covert Court. Now, Lori will tell you she had been inside that particular structure twice before. One time she was there with a third party. There was another male acquaintance with them, and they were there only briefly. The place struck her as being very small, because all she could see was a kitchen and a bedroom. On another occasion, she stepped inside when the defendant said he had to get something, and she was beaten back outside by flies and a terrible smell. She said the place stunk, so she waited outside. On September 11th, she offered to sit outside and read the Bible passages they had been discussing. Defendant said they should go inside to read. And on this occasion, Lori will admit she let her guard down and went inside and sat down. The only place to sit inside is the defendant's bed in the bedroom. On this occasion, she didn't notice any of the flies immediately, but she'll tell you that she noticed them later. She opened the Bible and began to read the passages, but he wasn't listening. The defendant ripped the Bible from her hands and violently assaulted her, punching her in the face, cutting his knuckle on his hand on her tooth in the process of hitting her. He told her she wasn't going anywhere. His strength and violence scared her. The defendant began to tear at her clothes. She could hear them beginning to rip. Eventually, between the physical assault and her fear that her clothes would be useless to her, she agreed to take them off for self-preservation. The defendant folded her clothes and put them in the corner, saying that she would be leaving soon. He then proceeded over the course of the evening of September 11th, all day on September 12th, and into the early morning hours of September 13th, repeatedly orally, vaginally, and anally raped Lori Svillick. He also physically assaulted her periodically. He told her she was going to die. This defendant put his hands on her neck and squeezed. She will tell you that she was ready to die. But her lack of struggle made him stop. The evidence will show that Elizabeth screamed and died. Stacy maced him and died. Lori accepted her fate, made no struggle or noise, and was allowed to live. On 2 occasions, the defendant left. When he did so, he tied her to the bed with the restraints that the police found that you will see in the pictures. He put duct tape over her mouth, and he tied her in a fashion that the ligature went around her neck so that if she moved, it would squeeze tighter, forcing her to stay still. You'll see her ligature around Elizabeth's neck as well. He robbed her, took her keys, and went to her apartment. The woman he tells Officer Dorsey is his fiancée. He burglarizes her. From where he sat in the hallway, he could see a shelf across the room in the living room where she kept a green change purse, where she would put her money when she came home. He says he went over, let himself in, took $43 from the green change purse that he could see on the shelf. He then went to Circle K on Main Street. He can be seen on that video entering the store just a little before 8 p.m., purchases a Polar Pop and a pack of Marlboro Black cigarettes with cash. When police officers entered the room and when the crime scene technicians processed the scene, next to the bed, with the restraints still attached, is a pack of Marlboro Black cigarettes and a Polar Pop. Defendant also made 3 phone calls as he exited the Circle K, all to someone named Brandon, pops up in his phone contacts, an individual that he transacts business with, since he was newly flush with Lori's money that he took from burglarizing her apartment. He did this after he robbed her of her key and left her naked, tied to the bed. He then came back to 363 Covert Court, put down the Polar Pop, put down the cigarettes, stripped off his clothes, and proceeded to continue to rape her. She told him it hurt. The internal injuries to her vagina are noted by the sexual assault examination that she underwent at the hospital on the 13th after she escaped the house. The defendant's solution was to smear Vaseline in her vagina. And in fact, there's a jar of Vaseline right there next to the bed so that he could continue to force his penis inside of her. You will hear from Lori. She is deeply traumatized. That is why she is referred to as Jane Doe in the indictment. You will see the razors the defendant took from Elizabeth's apartment. He used these razors. He shaved a heart in Lori's pubic hair. And when the hospital was done treating her after her escape, she was asked if she needed anything else, and she said yes. She wanted a razor and a place to go so that she could immediately shave off that heart, shave off that symbol of ownership, and try to get back to being herself. You will also hear from the defendant as he talks to Detective Major about trying to help Lori with her lustful desires. She needed to experience sex to get past her hang-ups. You'll hear this defendant tell Detective Major that he planned on keeping Lori and raping her since the first time he met her. You will also hear this defendant tell Detective Major that it was his goal to impregnate Lori's filling. He wanted her to have something to do and to care for in her life. He knew that her religious beliefs would not permit an abortion, even in such a circumstance. And while the state possesses the statement of the defendant and the statement of the victim, that isn't all the evidence pertaining to kidnapping, rape, robbery, and burglary of Lori's filling. He videotaped himself raping Lori as well. 9 videos of this defendant raping Lori's filling, taped on the same phone that he videotaped his rape of Stacey Hicks. So not only will you hear a victim tell you of her ordeal, not only will you hear the defendant describe his crimes, you'll see this defendant force his penis inside a crying Lori's filling. you'll watch this defendant force his penis inside a sobbing Lori Svillick. The defendant is charged as follows. Count 15. In that on or about the period between September 11th, 2016 and September 13th, 2016 in Ashland County, Ohio, Shawn M. Grate, by force, threat, or deception, removed another, to wit, Jane Doe, from the place where the other person was found, or restrained the liberty of the said Jane Doe, for the purpose to engage in sexual activity, as defined in Section 2907.01 of the Revised Code, and with the said Jane Doe against the said Jane Doe's will, and further, the said Shawn M. Grate did not release the said Jane Doe in a safe place unharmed, in violation of Ohio Revised Code, Section 2905.01A4, kidnapping. Specification 1 to count 15. Grand jurors further find and specify that the said Shawn M. Grate committed the offense in count 15 with a sexual motivation. Specification 2, the grand jurors further find and specify the said Shawn M. Grate is a sexually violent predator. Count 16, in that on or about the period between September 11th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate engaged in sexual conduct, to wit, vaginal intercourse with Jane Doe, when the said Shawn M. Grate purposely compelled the said Jane Doe to submit by force or threat of force, in violation of Ohio Revised Code, Section 2907.02A2, rape. Specification 1 to count 16. Grand jurors further find and specify the said Shawn M. Grate is a sexually violent predator. Count 17. In that on or about the period between September 11th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate engaged in sexual conduct, to wit, fellatio, with Jane Doe, when the said Shawn M. Grate purposely compelled the said Jane Doe to submit by force or threat of force, in violation of Ohio Revised Code, Section 2907.02A2. Specification 1 to count 17. Grand jurors further find and specify the said Shawn M. Grate is a sexually violent predator. Count 18. In that on or about the period between September 11th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate engaged in sexual conduct, to wit, anal intercourse with Jane Doe, when the said Shawn M. Grate purposely compelled the said Jane Doe to submit by force or threat of force, in violation of Ohio Revised Code, Section 2907.02A2, rape. Specification 1 to count 18. The grand jurors further find and specify the said Shawn M. Grate is a sexually violent predator. Count 19. In that on or about the period between September 11th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate, in attempting or committing a theft offense, did use or threaten immediate use of force against another, to wit, Jane Doe, in violation of Ohio Revised Code, Section 2911.02A3, robbery. Count 20. In that on or about the period between September 11th, 2016 and September 13th, 2016, in Ashland County, Ohio, Shawn M. Grate, by force, stealth, or deception, trespassed in an occupied structure, to wit, the residence of Jane Doe, with purpose to commit in the said occupied structure any criminal offense, in violation of Ohio Revised Code, Section 2911.12A3. Burglary. And after you take in all of the evidence relating to counts 15, 16, 17, 18, 19, and 20, the state is confident you will find this defendant guilty of kidnapping, rape, robbery, and burglary. Throughout this trial, you will hear several hours of the defendant talking to detectives in this case. You'll hear that conversation begin with denials and creep steadily closer to what may be the truth. Generally speaking, the defendant will admit to the crime as to his victims, Lori, Elizabeth, and Stacy. He admits unequivocally to the murder, rape, and kidnapping, but the details, the specifics, is either silent or vague. He directs Detective Major to a daily devotional book. It's in the bedroom, on a table, in the covert courthouse. He was tracking the days using this daily devotional, and there are 2 notations within it. He wrote the dates August 16th and September 9th, and you will hear him say that he did so that he could remember when he committed the murders. His vagueness as to Lori, Stacy, and Elizabeth stands in stark contrast to conversation with the detectives about property crimes at Charles Mill and the Mifflin Flea Market. There, the defendant is succinct and straightforward. You'll hear the defendant make his admissions to committing the premeditated killing of both Elizabeth and Stacy. These murders will constitute multiple victims that the state submits was done as part of a course of conduct. The evidence will show the defendant's methods are consistent and identical. Now, not only will you see the defendant rape Lori and rape Stacy, he consented to Detective Major videotaping him during an interview. He demonstrates how he strangled Stacy and how he strangled Elizabeth. We'll show you that video. Pay attention to that video. Look at his face. Look at his demeanor. You'll see the grin as he demonstrates his killings like it's no big deal. The doctor from the coroner's office will tell you that the defendant's modus operandi is consistent with his findings as to the cause of Elizabeth and Stacy's death: cervical compression, the slow deprivation of oxygen. It's the old sleeper home. The state of Ohio is confident that you will carefully examine this evidence, carefully listen to this evidence, carefully watch this evidence, and conclude that the defendant is guilty as to all counts in the indictment and all specifications thereto beyond a reasonable doubt. The evidence will in fact show beyond a reasonable doubt that this defendant was found asleep and naked in bed in a house that a terrified naked woman escaped from after being repeatedly assaulted and raped by this defendant. 2 decomposing bodies were found inside the same house, having been kidnapped and murdered by this defendant. The defendant subsequently, over the course of multiple interviews, confessed to every element of every crime with which he is charged. He demonstrated on video how he strangled his victims. He videotaped himself raping his victims. The evidence will show this is not a whodunit case. The evidence will show that this defendant is guilty of all 23 counts as contained in the indictment, all specifications thereto, beyond a reasonable doubt. Thank you, ladies and gentlemen, for your attention today and your attention in the future. Thank you.
Thank you, Mr. Tennell. Mr. Whitney, would you like to take a brief recess before your opening statement?
No, we don't have to, Judge. On behalf of the defense, we'll waive our opening statement. Stand on our pleas of not guilty. We're ready to proceed, Judge.
Thank you.